let's move on to some of the other things that we see people struggling with when they are trying to implement these powers of attorney. How many agents do we want serving under a power of attorney?
Ideally, one. You can have multiple in succession, but only one acting at a time is the ideal situation. There are several banks, including the top four, some banks in the top four, that will not allow two powers of attorney to act, or two trustees to act for that matter. So it kind of goes to your whole estate plan. But as far as powers of attorneys are concerned, they will not even allow it. They will not allow a power of attorney out of state. So it's very common for people to want to list all their children, or if you only have two, list both your children as co-powers of attorney, co-agents for you. And that's great, but a lot of times they can run into problems at the bank. And then, of course, there's the gold standard. Everyone gets along till they don't.
Yeah.
And then if they don't agree, the only tiebreaker in any of this is going to be a judge.
Right. And that is what we're trying to avoid by doing estate planning. Is we don't want families to have to go to court to help their older family members. So just name one. You can name the other kids as a backup. Just name one. So much easier. And what people don't necessarily appreciate is that a power of attorney is only good if the person you are presenting it to will accept it and honor it. Otherwise, it's just a piece of paper. And yes, there are laws that say if it's a validly executed power of attorney, they have to accept it. But
banks are banks, and financial institutions. This is surprising for a lot of people, but there is no standardization across the board regarding financial institutions in terms of what they're going to accept or not accept, or allow or not allow. So some might allow two co-powers of attorney, some might not. Some might not allow any powers of attorney. They're going to want their own power of attorney on their document, their letterhead, their, big bank form, or if they won't take it, what is it, if it's 10 years old or older? Things like that. They just get very particular, and you can fight it. But remember, if you're alive and incapacitated, now they're spending your money to fight your financial institutions.
Right. So yes, the law requires them to accept it, but if it's their policy to not accept it, now you're having to hire an attorney to fight, and they're going to kick it up to their legal department, and that's going to cost time, money, but most importantly, time.
Yeah.
And you don't necessarily have time. The point here is that you've got to make your power of attorney as good as you possibly can make it.